Constitutional rights class. How states deprive citizens of liberty illegally. Intro episode. Hello, my fellow Americans. Welcome to Constitutional rights class. Today's lesson will begin with the most important reason why we, the people, must know our constitutional rights. To protect ourselves from tyranny within the government, states, or military. How can we, the people, be a form of tyrannical behavior if the people don't control anything? The very reason why the United States Declaration of Independence was written for the benefit and use of the United States citizens. To help protect against the offense or defense of the state being used in such a fashion to deprive citizens of liberty, not to be equally protected by the laws. First, we the people must know where we affirm from, so that we the people use the law lawfully, because we know that is good. So how do we the people know that a state shall not deprive a citizen of liberty? We will have to go over to the Constitution of the United States, found at the 14th Amendment, Section 1. We the people will read the legal phrase of the highest law inside of the United States jurisdiction. And I quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. Nor deny to any person within its jurisdiction the equal protection of the laws." End of quote. The big question here is, does due process abridge the privileges or immunities of citizens to deprive liberty? Another way to ask the question is, does due process supersede, which is to abridge, the privileges or immunities of United States citizens? Second, we the people must know punctuation from language arts. In the 14th Amendment, Section 1 of the United States Constitution, as we previously read from the quote, "We, the people, will locate a semicolon." A semicolon connects two closely related independent sentences or clarifies a complex list with internal commas. The first part of the context that we read was pretty simple to understand as a normal person, except some people might struggle with the word abridge. So what does abridge mean as it is used here in the 14th Amendment as a verb? Abridge is defined as follows. 1. Shorten a piece of writing without losing the sense. 2. To curtail a right or privilege. And curtail means to reduce in extent or quantity, to impose a restriction on someone or something, to deprive someone of something. So to abridge is as a verb to shorten a piece of writing in such a way to curtail, restrict, or deprive someone of a right or privilege. Now back to the punctuational aspect of our lesson. As we the people observe the connection between two closely related independent sentences about the same topic? Or are we seeing a clarification between the conflicting sentences that discuss two different topics? Or is it a clarified, complex list of internal commas showing the sentence means all the same thing? In the quote of the 14th Amendment, we will see two semicolons. So that must determine that we are not observing a connection between two closely related independent sentences. Otherwise, the sentence would end with a period after the first semicolon. And that's not what we find. We see two semicolons in the sentence, and then the whole sentence ends with a period. By punctuation rules alone, we the people must be looking at a clarified, complex list of internal commas in the 14th Amendment of the United States Constitution. But how is that so? The first sentence in the connection of the three sentences was, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." The main topic of this sentence is that no state is able to make a law that deprives citizens of constitutional rights that are in the previous amendments before the 14th Amendment, nor reduce or impose a restriction on the citizen's right to the 14th Amendment privileges or immunities of any person inside of the United States border. After the first semicolon, we will read the second part of the sentence. Nor shall any person deprive, nor shall any state deprive any person of life, liberty, or property without due process. Nor shall any state deprive any person of life, liberty, or property without due process of law. The main topic of this sentence does have a connection to the first sentence through the word deprive and abridge, both meaning to not cause a restriction. The state not being allowed to restrict citizens of rights through the law. However, the end of the sentence, or the end of the second sentence, ends the sentence with a disconnect from the first sentence, which is the opposite of no state restricting privileges or immunities of United States citizens. The first two parts of the sentence connect with a semicolon are not closely related as two independent sentences. They are contrary to each other because of the due process clause. So, as a matter of fact, the semicolon is used to clarify complex lists with internal commas. So let's continue the clarification of a complex list or list with internal commas. Nor deny to any person within its jurisdiction the equal protection of the laws. With all three sentences linked together by a semicolon, a list will appear. Number one, no state can make or enforce any law that removes the rights of citizens. Number two, no state can deprive any citizen of life, liberty, or property because no state can make or enforce a law that abridges the immunities or privileges of citizens' rights to effectively use due process. And number three, No state is allowed to deny this 14th Amendment right to any person who is inside of the United States jurisdiction because due process does not deprive citizens of life, liberty, or property for the fact that no law is made by the state that can be enforced through due process of the state. So that the people, being any person, is equally protected by the laws while inside of the United States border, regardless if citizenship is acquired or not. What is the main reason why due process does not supersede the immunities or privileges of the United States citizens? Because there is an appeals process for any court case, which is due process. A judgment from a judge or a jury can be overturned, just like the decision of a law enforcement officer that makes or is made on the street can be overturned with due process in court by using constitutional rights in court. Due process is intended to be used in court by the people to make the state deprive fictitious entities like corporations, agencies, or businesses to be forced to give up life, liberty, or property with due process. Or maybe at the very most, make it possible to execute the outcome of a court case between two people. Now back to our question. Does due process abridge the privileges or immunities of citizens for the state to deprive liberty? Please write your hypothesis in the chat. The correct answer is no. That is an absolute negative. The state does not have the ability or right to use due process to abridge the immunities or privileges of citizens of the United States by way of depriving and denying liberty to the people inside of the United States, because there is no law that allows the state to do so for the fact that the Constitution makes it the way of law. The clarification of the complex list of the three topics makes things very clear for the average citizen to understand and uphold, but only if we know a little language arts and know what is good art. For instance, this section of the 14th Amendment of the Constitution is drafted in such a way to add mystery to the context, making the only way to solve the riddle of the mystery is to know punctuation and how to use punctuation the correct way. People who read this section with bad intentions of using the law might read this sentence of the 14th Amendment and breeze over this sentence, thinking that a state can deprive people of life, liberty, or property by using due process the wrong way, without using the correct punctuation standard. A person would assume incorrectly to think a state could deprive a person of liberty through due process, simply because there is no law that is made or can be made or enforced to abridge the privileges or immunities of United States citizens. There never has been a legal law to defy the United States Constitution, because no such law is able to be made. And if someone or something did make a law that abridges the rights of citizens, then that lesser law of the state is illegal, unlawful, void, and unconstitutional to be enforced as a law by the state. So, the state only has the exception to use due process to deprive any person inside of the USA border of life, liberty, or property if the person is not a citizen of the United States. Because due process does not abridge the privileges or immunities of citizens of the United States, for no law is made or enforced by the state indefinitely. Any person in the context of the 14th Amendment of the United States Constitution is describing any person who is a citizen of the United States. Any person in the context of the 14th Amendment of the United States Constitution is describing any person who is not a citizen of the United States. A supreme law of the land covering over any person, whether they be an illegal alien, a legal immigrant, or some kind of ghost. Due process does not abridge the immunities or privileges of citizens in the United States. Due process of the state can only deprive a person of life, liberty, or property if the person is not a citizen. The forefathers who wrote the Constitution of the United States did in such a fashion to give plenty of room for the people to make correction, not for the people to be forced into some kind of correction program. Yet, our privileges or immunities as constitutional rights must have been stated before the 14th Amendment. And in a later study, we the people will do a deeper dive into the subject, exploring those ancient artifacts. For now, we will learn of an example of how the state is and will continue to be unlawful by abridging those constitutional rights of United States citizens. The state will use color of law. That's what we see in society as the option of trial or pretrial in courtrooms. Color of law is not constitutional law. Therefore, constitutional law is more powerful than due process color of law, proving that due process does not deprive U.S. citizens of liberty and only U.S. citizens of the United States. Normally, what we'll see in a criminal case is due process is used by the state to deprive a person of life, liberty, or property. That is 100% unconstitutional, no matter if armed law enforcement officers attempt to force you into a color of law courtroom. The armed law enforcement officers are forced to obey their oath of office to uphold and defend the United States Constitution, which is the free exercise thereof, an establishment of religion that no law prohibits, as a First Amendment right. Hence, denying color of law through due process. Example 1 of the state using the law to abridge the privileges or immunities and constitutional rights of U.S. citizens unlawfully and illegally. Take Florida Statute 709.01 through 08 as an example. In the 2025 revised statutes of Florida, the new law is made to show 709.01 through 07, missing Section 8 from the 2010 revised Florida statutes. Most people would not see a problem because they are blind to the issue at hand. The problem being the state has violated the United States Constitution. But how is the 2025 revised Florida statute violating the U.S. Constitution? if you've been paying attention, you should already be able to answer this question. Although, why are the people blind to this problem? The state of Florida is completely abridging the immunity or privilege of a citizen to be an attorney in fact. The state has made a law that restricts the ability to be an attorney in fact, which is to abridge the immunities or privileges of citizens by hiding Florida Statute 709.08 as the 2025 revision aims to terminate the usage of an attorney in fact, denying to the people of the United States the equal protection of the laws. Located in the 2010 revised statutes of Florida, we the people will find a clear definition of what an attorney in fact really is without any doubt in any person's mind. Unlike the 2025 revised statutes, which is purposely confusing, misleading, and vague, the 2010 revised statutes are precise, easy to understand, is in good faith, and falls in line being in accordance with the United States Constitution. Plus, the 2025 statutes shorten a piece of writing in the 2010 statutes that imposes a restriction on the rights of someone to use the attorney in fact protection of the law. The correct answer is yes. The state is abridging the immunities or privileges of citizens with the 2025 revised state statutes of Florida to remove attorney in fact from the law as an equal protection of the laws. Therefore, the new Florida law is unconstitutional. Discovering that the 2025 revised statutes of Florida fall short, being fractured in structural integrity, contrary to the supreme law of the United States Constitution, void, and the state of Florida's ability to enforce any power of attorney from the 2005 statutes is removed for making a new law that abridges the privileges or immunities of being an attorney in fact. And that's attorney-in-fact, meaning that the state of Florida shall revert back to the 2010 statute of 709.08 when any person wishes to use and appear as a power of attorney or an attorney in fact, especially if that person is a United States citizen. Now ask yourself why the state would attempt to remove an attorney in fact and fail doing so. More importantly, why is the 2025 revised Florida statutes of 709.01 through 07 unlawful, illegal, and unconstitutional? The 2025 revised Florida statutes violate the First Amendment of the United States Constitution, where no law prohibits the free exercise thereof and establishment of religion. The people inside of the United States can easily understand that the 2010 revised Florida Statute 709.08 parents 2 is clear and easy to understand and requires a nonprofit corporation organized for charitable or religious purposes that has trust powers and which is a tax-exempt organization under 26 United States Code Section 508c3. Religion is the only way to do 508c3 tax exemption. The key word being religious. Connecting Florida Statute 709.08 Parents 2 over to the establishment of religion that's in the First Amendment of the United States Constitution. The supreme law supports the lesser state law in 2010, and vice versa. The lesser state law is supporting the First Amendment of the United States Constitution, creating equal balance in the law so that a U.S. citizen can be equally protected by the laws legally. The correct way of lawfully using the law. The 2010 revision of Florida Statute 709.01 through 08 is correct, legal, lawful, and constitutional. The 2025 revision of Florida Statute 709.01 through 07 is wrong, illegal, unlawful, and unconstitutional to remove the attorney-in-fact section, bringing us, the viewer, to the point of why it is very important that we, the people, understand and use our constitutional rights. Look at the 2010 state statute of 709.08 Parents 2 in Florida and know the real reason why the state abridged the liberty of citizens. Look very carefully. An attorney, in fact, has a sound mind, something the United States government doesn't want you, the citizen, to have. In your own possession, without the state's approval, to be of sound mind. Just imagine for 1 second. If the state of Florida attempted to trick citizens into thinking there is no such thing as an attorney-in-fact, because the state acted illegally to abridge the privileges or immunities of being an attorney-in-fact by making a new law that completely removes the legal phrase of attorney-in-fact. Or think about 100 years from now, the people in year 2126 would have to find this legal option of being an attorney-in-fact in year 2010. By that time, the Florida Statute 709.08 Parents 2 might be forgotten entirely. All because a small group of individuals called legislators decided to be unconstitutional in their duties by making a law that is against your free will to change a perfectly working statute and deny the people the liberty of equal protections of the laws. Do not forget that you may still use Florida Statute 709.08 Parents 2, who may serve as an attorney-in-fact. This is an introduction to the constitutional rights class. In the first class study, I hope to do it as a live stream so we can all have input in the comments. Future studies will focus on sentence structure, punctuation symbols, and context meaning. It is more important to know our constitutional rights than to go to work at a job, because without constitutional rights, the workplace becomes an employment of slavery. Your future is your own to write. With faith in God and the United States Constitution, the possibilities are endless for mankind. In Jesus Christ who strengthens us. How will you use the law lawfully, being good? A Bible verse to keep us on the right path. 1 Timothy 1:8, King James Version. But we know that the law is good if a man use it lawfully. So, To recap on the knowledge that we, the people, has just learned. Due process does not trump our constitutional rights of privileges or immunities while being a citizen of the United States. Even a federal courthouse is inside of a state, which means constitutional rights are to override due process. Due process is not a gunshot to the head of a United States citizen by law enforcement officers. No trial takes place if any person inside of the United States is shot and killed by law enforcement officers. Therefore, we the people may never know the real truth of an incident that transpired under the watch of the law, unless a trial is present. Due process can only deprive a person of life, liberty, or property if, and only if, due process does not abridge or deprive a citizen of the United States constitutional rights, such as privileges or immunities. Stay tuned. That's all for now, folks. This television broadcast is brought to you by Daily Bread Ministry Trust. Size the Saint, over and out.